So by way of introduction on this topic, that is the establishment, composition, and jurisdiction of Nigerian court with emphasis on customary and area courts, I would like to establish that the Nigerian court system is a very vital institution for the maintenance of law and order. And like we always say, that if the court system is not in place, we'll probably be living in a society where there will be total breakdown of law and order. So the existence of the courts helps to sustain human rights, which of course cuts across protection of life, protection of property, and enforcement of whatever laws you may have, whatever rights you may have under the Nigerian law. And the court system at the same time is a backbone of the judicial arm of government, as provided for in Section 6 of the Constitution of the Federal Republic of Nigeria. And that in so many ways provides or gives us or further explain how important the court system is. And that understanding will also give us the need, or provide the need to understand the various courts that we have within our judicial system. And just like I'm sure you already know, at least based on the court structure, that the Nigerian judiciary or court system operate what we call the hierarchical structure. Because we talked about the establishment of courts from the highest to those that we consider as lower courts or inferior courts. And of course, we know that Nigeria operates a plural legal system, which is made up of the English law, that is the received English law, which comprises of the common law, doctrine of equity, and so on and so forth, and our own indigenous customary law, which over time we have established that they were able to take care of the basic needs of the society even before we were colonized. So this aspect of our law that talks about the fact that our system is has this pluralistic nature, it also reflects in our courts, the courts that we have. Because when you talk about the Supreme Court, for example, as a court of record, it does not deal in matters that pertains to maybe elementary customary issues, except cases that have traveled all the way from the magistrate court, maybe to the High Court, Court of Appeal, and there are issues of interpretation of some certain aspect of our laws. That's when the Supreme Court, can come into anything that pertains to the elementary parts of our customary law. But we notice that by the nature of the Supreme Court, it deals with complex cases, most of which we have roots in the English legal system. And then you begin to look at the divide, that those higher courts, superior courts of records, will fall under court that deals mainly with English affairs or English system. Why the lower courts, like the customary court that we want to look at today, the area court, will focus more on those issues that are very elementary. So, in order to ensure justice within our system, through the system of courts, then the courts were created to meet different needs of the society. And of course, we see that the customary law is an integral part of our laws. And where we have the customary courts, customary law applicable to situations, then the customary court comes into play. And there are areas of the country where the customary law, customary court can be found, not in every part of the country. Same also applies to area courts, which also can, be found in some certain segments of the country. But the good thing about these two classes of courts, whether the customary courts and the area courts, is that they bring justice very close to the people, and they make it accessible that individuals, even with little or nothing, could approach the courts either to claim a right or to have his or her rights protected. And I'm sure when you were dealing with hierarchy of courts, you talked about Supreme Court as a court of record, and the basic characteristics of that court, being the highest court in the land, deals with very complex cases. And at the same time, it is not easily accessible. You can ask some of your seniors who are in practice that if they have a case that is going on appeal to the Supreme Court as of today, you may not get a date in 2027. Maybe the date they will give you will be somewhere around 2028. It's far. It's because the cost diary is up to that time, probably loaded. But this lower court that we're talking about are accessible in that we can, approach them easily, and then we'll be able to get justice to some level. So that is one of the major reasons why it's important for us to look at the composition of these courts. And in looking at the composition, we look at the establishment and the various subject matters that they also deal with. So it's important that you understand the establishment superior courts. While on the second part, you see inferior courts, which are generally or mostly established by state laws. And the court we are focusing on this evening is an example of those inferior courts established by state laws. And this inferior court will include the customary courts, area courts, magistrate courts, and mobile courts. And the good thing about it is that even though they are a product of the exercise of the power bestowed on the states, the Constitution, by virtue of Section 6 down, gives the states powers to establish these courts. And it's more like a clause that we even provide more avenue that if the state feels that tomorrow there is need to establish a court to take care of a particular matter, by virtue of the provision of that law, the state can go ahead to establish such courts. Now let's focus on customary and area courts on the issue of establishment. Now, from what I've said, you will observe that customary court is usually the creation of the state. And this is so because of the peculiar needs of the various states. So when you look at the various laws of the different states, you'll see that they establish the customary law, the customary courts. And as to the function or the composition of the courts, the customary court is usually consists of a president who serves as the judge and 2 or more members. And of course, when you look at their qualification or what should lead to their appointment, this set of people, either the president or the judge and the other members, must be people who are versed in customary law of that particular place. For example, if you are not from Edo State, it will be difficult for you to understand the customary law of the states. And by virtue of that, you do not fit to be appointed to administer cases that may come through that customary law. So what I'm saying in essence is that those appointed who makes all these courts are expected to be versed in what? In customary law of that particular place. And oftentimes they are not expected to have acquired so much education or legal education, provided it can be established that these individuals know the custom of the people and as well can apply same in line with the rule of justice. Then they are fit for appointment as members of the courts. And then the customary court of appeal is now a different ball game altogether on the issue of the officers of the courts. Because I did say that the officers of the customary courts or area courts, so to speak, are not required to have so much qualifications. But that is different from the customary court of appeal. Okay? And the customary court of appeal takes appeal from where? From the customary court. Meaning that to some extent, that is a superior court to the customary court, and the expectation on the part of the personnel who will work there is usually higher compared to what we have at the customary court. So meaning that there's expectation as to qualification relating to legal studies, aside the knowledge, the required knowledge in the custom of the particular place. But on its composition, on its establishment, we have established that customary courts is put in place by the various state laws. Okay? And then it consists of the president and 2 members who serve as the personnel of the court and also who are expected to be versed in the customary law of that particular place. Now, as to their jurisdiction, I believe by now we know what we mean by jurisdiction. That is the legal authority that a court possesses to entertain or decide a particular course of action. So, as to the jurisdiction of this court, that is the customary court, they are limited, so to speak, to specific area, and also because it's an aspect that covers a particular area. Okay? And their jurisdiction will cut across matters pertaining to custom. It can even be to the extent of validity of such customs, or issues pertaining to traditional land ownership and all of that. So, but the point you need to take at this point is that while other courts may have a wide range of subject matter they can attend to, the court under consideration is limited. Okay? And the courts also have mentioned that the courts, customary courts as we speak, cannot entertain issues outside the customary law. You can take the case of Ogunleye and Oni, reported in 1992 Nigeria Weekly Law Reports. The court established as it relates to the jurisdiction of the customary courts that the customary courts cannot entertain issues outside customary law. And that means the courts cannot even entertain land held under statutory right of occupancy, because that will amount to the court to look at the Land Use Act, and the Land Use Act is already outside the scope of what the customary court can do, what can look at. Also, the customary law will not be able to engage cases that has to do with contracts, because when you look at a formal contract, you see proper elements of English jurisprudence in it. The question then therefore is whether the customary court will be able to determine what a valid offer is, or whether the courts will be able to dissect what the concept of acceptance is all about. After acceptance, you have consideration, and so on and so forth. But the law of contracts is more of the English setup. So therefore, the customary courts cannot venture into such cases. Like I said, the case of Ogunleye and Oni gave a blessing to that position of law. And I think if you do not take anything down, you need to take that down to support whatever argument you may have under that. So, as to the role of the customary courts, the customary courts administer customary law strictly, and not just customary court law, but customary law applicable in a particular locality. So meaning that the customary court has a lot of limitation, because number one, like we've said, this law is not of a general application. Its focus is on a particular location or territorial space. Apart from the fact that we said that it cannot deal with issues of contract, of statutory land ownership under the Land Use Act and all of that. So, strictly speaking, the customary court administer customary laws applicable in a particular locality. So, meaning that in a state like Lagos, the customary laws of the Badagry people, are they the one we call Ebu? Right? May be different from the Awori people, even though they are still within the same states. Now, not to talk of when we're talking about traditional inheritance and all of that as it relates to Ori Ojori, Idigi kind of system, the Giogbe system and all of that. These are different customary system of different states. So the territorial space is what also limits the administration of customary law. Also, please know that customary law exists in southern Nigeria, while the area courts exist in the northern parts of Nigeria. And like we said earlier, they are to provide accessible and affordable justice that is rooted in local values, especially as it relates to the law of the place. Okay? The customary courts exist in the southern part, while the area courts in the northern Nigeria. And like we've established that its aim is to provide accessible and affordable justice rooted in local values. And for example, the customary one example of enabling law setting up customary courts in the south is the customary court law of Lagos State. And when you want to also look at examples of laws that have set up the area courts, we can refer to area court laws of Kaduna State. Okay? And that buttresses the fact that each state do have their own laws establishing the courts, as the case may be. Now, to further talk on the jurisdiction of these courts, like I said earlier, that the courts have held that customary courts cannot entertain issues that does not fall within customary law. So, meaning that customary law will apply in terms of jurisdiction to marriages conducted under customary law. Okay? To marriages conducted what? So, everything that may surround that marriage, whether it's divorce, whether it's ownership or child bearing, childbirth, legitimacy issue, and all of that, may be governed by that, but to some extent. So, the customary court can deal in matters of marriage and divorce done under customary law. Now, as I was saying that, I recall that in Nigeria, as we speak, or in the southern part, if two individuals that are married under Islamic law want to divorce, they go to the customary courts. Are you aware of that? You've not divorced before, so you will know. Now, why I'm saying that is this. We have argued that Islamic law is not what? Is not customary law. Then the question therefore is, why should the marriage conducted under Islamic law be dissolved or made to be dissolved in the customary courts? Well, we may want to look at it from the angle that the attempt to classify Islamic law as a distinct law is probably just to preserve it by virtue of the religion. But if you look at these interactions of customary law, customary court entertaining marriages conducted under Islamic law, then you still want to give credence to the scholars who said that Islamic law and customary law are the same. But that's just aside. We cannot determine all of that here because we are also permitted to be jurisprudential about this discussion. At least I've thrown it up is in your mind. So that if at all you happen to come across a query suggesting that customary law and Islamic law is the same, what will be your argument? That's the issue that I want to make you understand and cause that stir in you to ask. And in arguing, it's neither here nor there, because the expectations of different lecturers are not the same. And that was why when I was grading some of your scripts, what is it? Okay, let me continue my lecture. Especially when we're talking about your test. We talked about Mr. Adebayo and Mr. Chike. Many of you don't like Mr. Adebayo. That's why in your argument you said that Mr. Adebayo will be liable. Yeah, this one has even forgotten. May God have mercy on all of you. All right, let me read the question. Let me read the question to you. Are you with me? Or we should skip it? The National Road Traffic Act provides that. Can you listen, please? The National Road Traffic Act provides that, and I quote, "It shall be an offense to operate a vehicle on the highway if such a vehicle is a car, truck, bus, or any other similar mode of transportation." The question is this: Mr. Adebayo was arrested while riding on an electric scooter on the highway and charged with violating this provision. He argues that an electric scooter is not covered by the law because it was not explicitly mentioned in the list. And I asked, using the ejusdem generis rule, analyze whether Mr. Adebayo has a valid defense. Would the court likely interpret any other similar mode of transportation to include electric scooter? And I saw plenty arguments. Yes, and that's where I'm going to. In the display of the liberty to argue, you cannot throw away the substance. Many people throw away the substance. Now, you can argue on the ground that, okay, I'm sure that many of you have not seen electric scooter before. Do you know that electric scooter also has 4 tires? Do you have your phone there? Google it. So, you said what? I've done what? So, okay, let's go there now. Electric scooter has 4 tires. But those 4 tires sit on just something very small. And sometimes some design we have just 2 tires. Okay? And then it is a kind of a mode of transportation that can walk or that can move on the roads. And that confused a lot of you. But the question is, if you argue this way, that yet this machine, electric scooter, can apply the same road where the bus, the car, the truck will. But what is the body structure like? What is the composition? And the configuration of a car is similar to a bus. Am I going somewhere now? Is similar to a truck. And is similar to which other one did you mention there? Truck, car, bus, okay, and any other boat. So why on earth do you think that an electric scooter will fall into that class? It is not in that class as of today, and it will never fall into that class. But many of you heard the view that it is, and that Mr. Adebayo must be punished. And let me shock you. And in the process, you got yourself punished. You see, that's why it's not good to have bad belly for people. Hello, class. That's why it's not good to have bad belly for people. What? No, I think I'm interested in this. Hello, class. Yes, yeah.
So what if you are thinking from the perspective that they are all mechanically powered?
Okay. Okay. I've just been told, hello class, I've just been told that many of you have not seen electric scooter before. Why are you so local? Why are you so local? And when I see you, hello, and when I see you around, you do like this, you do like this, you do like, and you have not seen an electric scooter before. You see, now, it was argument that led us there. It's good to act to play safe. If you had told me that, number one, that a lot of things actually determine the judgment that the court gives, that it is possible for the judge to think that because that same mode of transportation moves on the road, then it can fall or it may not fall. You act somewhere, but for you to categorically say that it is not is dangerous. So 98% of this class argued that electric scooter is in that group. No be so. It's not. And that was why some of you made very solid argument for and against. And when they got to the conclusion, they said it is not likely because of the body structure that electric scooter will fall into that class. And they concluded that's 14 marks. Okay, let me conclude my class. Can I conclude my class? Wristwatch. No, wristwatch. Wristwatch. Hmm? So let me conclude the topic. Then we can talk about the other ones. Oh, you don't want? You want? All right. So, in terms of jurisdiction, we did say that the jurisdiction of the customary court is limited to matters under customary law, such as marriage and divorce under customary law, land held under customary tenure is another example of the jurisdiction of the customary court. We also have chieftaincy matters. Chieftaincy matters. Then inheritance and succession under custom. Inheritance and succession under custom. Now, if you look at that last word, now if the issue is whether or not an adopted child falls within this class, will the customary court be able to look at it? Why? Sir? Adoption is is foreign to customary law. Now you chop my 5K that time, I know. Yes, it's foreign to it. So it may actually exclude it. So, of course, when you apply your understanding of what we are talking about, you will actually know what can fall under or what cannot fall under. But please note that the criminal jurisdiction of customary law, customary court have been taken away. Okay? And of course, because the constitution has, taking care of that, in that nothing is an offense under the law except it is what? It is written and the punishment thereof provided. And because customary law is largely unwritten, where then do we find those crimes? Okay, so I agree with the remover. Okay, so this same thing also applies to the area courts. And then when you look at the relationship between customary court and other courts, or the relationship between area courts and other courts, you will see that appeals from customary or area court goes to the customary court of appeal or the high courts, and then from there it can travel as far as it so desire, but it goes first to the customary court of appeal or the high court, depending on the structure. And then still on the relationship between customary and area court and other courts, the high court or the other higher courts or the appellate court retains supervisory jurisdiction over the customary court and the area court, meaning that they can review their judgments, upturn same, or modify whichever is called to question. Then the challenges relating to this court system is that there is no uniformity across states. I'm sure you will agree with me, because the various states have their own customary law, which automatically affect the composition of the court or the function of the court, and so on and so forth. And then lack of legal training is one of the major challenges of the two courts that we're talking about. So in conclusion on this topic, the Nigerian court system reflects both the colonial legacies and the indigenous legal system. Okay? The Nigerian court reflects both the colonial legacies and the indigenous system. And that can simply be explained that the two systems, the English system, the indigenous system, one way or the other, interact and they still exist within our society, and we still deal with them, we still interact. Matters from them still also go to the court, and we continue to live together, mostly because we can't do away with our indigenous beliefs and system. So while Nigerian courts reflect both colonial legacy and indigenous system, the superior courts are constitutionally established and legally formal, unlike the customary and area courts that focuses on grassroots justice. The superior courts are constitutionally established and legally formal, but customary and area courts engages some flexibility and informality in order to ensure grassroots access to justice. But in all, both still serve the purpose of meeting justice in the land and to ensure that justice prevails in the society. So basically, that is the summary of the lecture on the topic establishment and composition of and jurisdiction of Nigerian court as it relates to customary and area courts. Do we have any question? Any question? Yes, please.
I understand that magistrate and customary court, is it possible to take a customary state to magistrate or it's not possible? Because I mean, criminal has to be like customary, but then I feel like since that is like inferior, you cannot take customary state to magistrate since it's within the system.
But that may not be a good idea if the issues involved are purely customary issues that will require those, because at the magistrate level, whether you are versed in a particular custom may not be a yardstick for appointment of magistrate to that court. So when you now bring a matter of customary law, the magistrate may not be able to do justice to it. So it's better that we engage the customary court, and whatever the offshoot is, then the magistrate court can. But of course, the appeal from there go to customary court of appeal. Yes, any other question? Yes, please.
For area court that is located in northern Nigeria, do not appeal also go to customary court here? The structure there.
Yes, depending on the structure. But in the north, it's likely to go through the Sharia courts. Okay? Because some of the court dealings of the area courts will be customary, but popularly called Islamic, because we don't want to say that Islamic law is customary. Okay? So depending on the structure in the location. Yes. Yes, please.
As regards to the composition of the customary court, you said a president to serve as a judge. I want to ask that who is the person who appoints the president of customary courts?
It is still under the government of the states. Okay? Of course, the judicial structure as to appointment, everything is within. All right, so let's stop on that.